Detained protesting Aam Aadmi Party workers as they attempted to march towards the Prime Minister's residence. BJP workers also protested outside the Secretariat, seeking Chief Minister Arvind Kejriwal's resignation. The Delhi Chief Minister has issued a second directive while under ED custody, asking his nodal minister to address issues related to healthcare services. This brings us to the big question. Is Delhi staring at President's rule? What does the law suggest? Ashmit joins us now with more. Ashmit, what next for Delhi?
Delhi Chief Minister Arvind Kejriwal was arrested late at night on March 21st by the ED. He was then remanded to the ED's custody till March 28th. But interestingly, there is no message either from the Aam Aadmi Party or Kejriwal about his willingness to resign. So what does that mean for Delhi? Is the national capital facing imposition of President's rule? Let's take a look. First up, is Kejriwal required to resign? The Representation of People Act of 1951 provides for a 6-year disqualification of MPs and MLAs. However, this disqualification is triggered only in case if the accused MP or MLA is convicted for specific offences. Kejriwal is currently facing charges by the ED and is an accused, is not a convict. So as per legal experts, he is absolutely under no legal requirement or obligation to resign. But is it practical to continue as the Chief Minister? Well, operating as a sitting CM from jail presents its own unique challenges. As per the Delhi prison rules of 2018, an under trial is permitted visit by family, friends or advisors only twice a week. With this cap of twice a week, a sitting CM will face difficulties in meeting ministers and officials, taking executive decisions and signing files. Some legal experts have flagged how Kejriwal will be unable to discharge his duties as the CM, and that will render the national capital headless. They further reason that a headless government could be interpreted as a failure of constitutional machinery. Now, interestingly, the Constitution is silent on what qualifies as failure of constitutional machinery. So that begs the question, can the LG invoke President's rule citing failure of constitutional machinery? Well, the invocation of President's rule in Delhi is as per Article 239AB of the Indian Constitution. Under Article 239AB, the LG can submit a report seeking President's rule in case the administration of the national capital cannot be done as per constitutional provisions or, if necessary, for proper administration. Now, Article 239AB provides the President with sweeping powers to suspend the Assembly's power to legislate, suspend or dissolve the Assembly altogether, or even make laws for daily administration of the national capital. Which brings us to another question. What has been the fate of previous governments that faced the President's rule? Well, Kejriwal would be well advised to factor this in. Between 1952 and 2019, President's rule has been imposed a total of 123 times. Of these times, the dismissed party has come back to power only on 44 occasions, and the dismissed CM has returned to power only in 24 instances. Now, this is something that Hemant Soren was careful about. Hemant Soren, the former CM of Jharkhand, is a recent example of tactics being used to avoid President's rule. Hemant Soren, facing possibility of ED arrest, made the tactical move of resigning from his position as a CM. Prior to the ED arrest, he placed his resignation before the governor, while simultaneously allowing second-in-command Champai Soren to stake claim to forming the government. Now, the Lok Sabha elections are around the corner. The Aam Aadmi Party government's tenure in Delhi also ends in February of 2025. And while the Delhi CM suffers the wrath of the ED, he is holding his cards close to his chest.
Ashmit, many thanks for joining us. Our Delhi court has sent